Thank you, everyone. Welcome. Thank you. It's 2 o'clock. Ready to get started. Welcome to Everything on Expert Witnesses. My name is Carlson. I'm a partner at Casper, Meadow, Schwartz & Cook, personal injury, wrongful death law firm, plaintiff side. It's been in the county for 40 plus years. And I'm excited to be the moderator for today's presentation. We have some excellent panelists. We're going to be covering everything from the retaining experts to depositions, prepping and taking opposing experts' depositions, all the way up to trial matters. And this presentation is a continuation of a trial series that was put on by the litigation section earlier this year that covered basically everything you would want for litigating a case. Depositions, taking and defending, pleadings, jury selection, direct and cross-examination, and trial presentations. So if you're in here, you probably do some litigation. Those might be of use to you. They're pretty serious on.
That could get dangerous.
Those presentations are available on the website on demand if you want to check them out. And if you really want to get good at your trial skills, we're having an experiential trial practice course in March. It's hands-on. You're going to actually be doing the cross and direct and the openings with an instructor right there with you. It's going to be a 3-day course. Only 16 participants. There's going to be a lot of instructors to participants, really good ratio. That's going to be March 9th, 10th, and 11th. There's only 16 spots available. We do expect it to fill up. But if you really want to hone your trial skills, that's where you can come and you can watch your friends and colleagues see what they do and try and learn some things from them and try things out that maybe you wouldn't want to try in front of a jury and see how it goes and learn from some really good trial lawyers. So look out for that if you do want to participate. To introduce our speakers, we have Jaime Herren, who's going to be covering depositions, all aspects of expert depositions. She's a patent and trust and estates litigator at Holland & Knight. She handles trust, estates, IP portfolios for individuals and fiduciaries. She also works with cryptocurrencies, NFTs, which I have no idea what that is, even though I Googled it, and other electronic and digital assets. She does dispute resolution, dealing with licensing deals, and property, estate planning, things like that. And I've gotten to know Jaime through the litigation section board, and I've always felt like, you know, we deal with a lot of smart people, but she's like a different kind of smart. Like, what's going on with that? And I recently learned that she was, before a lawyer, a rocket scientist. So she worked for Pratt & Whitney Rocketdyne, which they designed and produced rocket engines. She was a flight test engineer for the main engines of the U.S. Space Shuttle, and she was in the control room for the July 4th, 2006 Space Shuttle Discovery launch on a mission to the ISS, and I looked that one up, and that's the International Space Station. so very impressive. And we have Todd Walburg, who's going to be going over all matters dealing with retaining an expert and that sort of process. He's been practicing in the Bay Area for over 20 years. He's a partner at Bailey & Glasser in Oakland, previously a partner at Leaf Cabraser in San Francisco, focusing on plaintiff side product liability and catastrophic injury cases. He was a finalist for the San Francisco Trial Lawyer of the Year Award in 2021. On a personal note, he lives with his wife and 3 kids in Moraga. And a fun fact about Todd, he plays water polo twice a week before work, and recently has taken up spearfishing in Hawaii, which sounds pretty nice, and he's going to try and do that in Northern California sometime. And we have the recently retired from the bench, but not retired completely, Judge Baskin. And he's going to be covering trial matters, things that come up inevitably with all experts during trial issues. And I was researching what to say about him, and there's just too much there. We have only a 90-minute presentation, but a few highlights. He served on the Superior Court for approximately 20 years, and he was honored as the Trial Judge of the Year in 2009 by the Alameda Contra Costa Trial Lawyers Association. And I think one of the more impressive things was he was serving as the presiding judge for Contra Costa County in 2020 when COVID happened. And as someone who practices in many jurisdictions, Contra Costa did a great job through that. And so kudos to him for navigating that new and difficult time. On a personal matter, was what I found interesting was he's the first person appointed to the bench in California who was born, raised, and trained in South Africa. So he's South African, and I love his accent. And as a triathlete, what I like about Judge Baskin is he has completed a number of Ironman triathlons, which is a 2.4-mile swim, 112-mile bike ride, and a marathon. And you get 3 years to complete it. No, just kidding. Do it in one day. And he's done a number of those, which is very impressive. And speaking with his wife, she let me know that one of the main reasons why she married him is for his smoked brisket and sourdough breads. So we have an excellent panel. I'm going to have Todd Walburg start us off. And
all right. Thank you so much for the kind introduction, Adam. It's been fun meeting all these folks and working together on this panel. So as Adam mentioned, I do a lot of product liability cases, and in those cases, experts are really the most important thing. So many technical issues, and we're always going up against an opponent that has unlimited resources and access to engineers and every expert you can imagine. So the way I look at experts in my cases is I kind of consider myself like the captain of a team, and I think about, you know, how do I want to put together my team to win this case? And I think long and hard about it. I think about, how is this person going to be received by the opposing counsel? You know, are they going to think, oh, this is a quack, or are they going to be intimidated, which is what I want? And then I think about how the judge is going to receive this expert. You know, don't tell the other judges, but sometimes I'll do a little background check, not a background check, but I'll look at the bios of the judge and see if there's maybe any similarities between the expert and the judge, like former military service or something like that. And then as far as how is the jury going to accept and respond to the expert, and that gets really into looking at the jurisdiction that I'm in, you know, if it's more rural or if it's in the city. And I do cases all over the country, so sometimes I have to do research and talk to other lawyers that I know across the country to find out, you know, what is the jury pool like here, and you know, who will do well in this jurisdiction. So I really put a lot of thought into it on the front end, and so that's why my first point is do your research and homework on the front end, and then think about everyone involved and how they'll receive the expert. Because in addition to being a member of my team that I've put together, I also want them to guide me and, you know, make me feel confident throughout the case. So, you know, and there's different factors to think about. You know, one of the things I think about is it important for me to have an expert who's really seasoned in the art of litigation, because that can bring a lot of advantages. But there's also disadvantages, because then that person has probably testified so many times and you know, could be considered biased, because a lot of the experts tend to do mostly one side or the other. So mostly plaintiff and mostly defense. And I know we have probably a mixed group here today, but everything holds true. It's rare to find an expert who splits their time evenly between plaintiff and defense. But they are out there.
And I'm just going to interject a little bit because I think we're going to have a lot of back and
Yeah.
forth going on here. So in my practice, in trust and estates and IP litigation, I use different kinds of experts. I don't think I've ever used a product liability expert. So I use a lot of valuation experts, and they're not plaintiff or defendant side. They're just going to value something. Or a comp expert. Experts on industry, and then also standard of care experts. So in trust and estates litigation, it's often a bench trial because in probate you don't have a right to a jury. So a standard of care expert, all these considerations he was just talking about, your audience is the judge and educating the judge. So you definitely don't want somebody intimidating. You don't want somebody pompous or arrogant because the judge is the smartest person in your courtroom. So you don't want to bring in anyone smarter than the judge, right? You want someone who's friendly demeanor, who the judge is going to like them, and also respect them, right? So so really the type of expert you're looking for is going to bear on all of these things, and your audience is very important. So I start every case with jury instructions, and that's where I find my elements, right? And if I need an expert to prove one of those elements, right, that's where you start building. Who am I proving this to? Am I before a jury? Do I need a standard of care expert to explain something to a judge? Do I need a technology expert to explain something to a judge? If you're explaining to the judge, that's slightly different than if you're explaining to the jury, right? Also your opponent. You already spoke a little bit about if you have a big opponent that's going to come in with corporate lawyers and nice experts and they're going to be polished, do you need to be polished? Or do you need to be friendly? Right, so all of these things, they're part of your initial strategy, and you should think about them up front. When you're looking at those jury instructions, when you're drafting your petition or your complaint, those are the first times that you need to kind of start thinking about, like, what expert would I use to prove these elements?
Yeah, those are really good points. Thanks, Jaime. Yeah, I don't think, I almost never do court trials, judge trials, but I think I would have a totally different frame of reference if I was just going before a judge, because for the reasons that Jaime stated.
It's also very different in federal and
Yeah.
state court, like kind of just a different tone in that courtroom, so.
Right, and then also in federal court, of course you have to realize that the standards are more stringent with Daubert. I'm briefing Daubert issues right now in a class action case I have against Nissan. And yeah, there's just, the federal law is just so much more particular and demanding than California state court law on experts. So that's something definitely to think about.
Can you give a quick summary of what Daubert is, just in case someone doesn't practice with not familiar with that case?
Yeah, that's the federal, universal federal court standard that deals with the admissibility of expert witnesses. And kind of the gist of it is the person can be qualified by their training and background or experience, but there's a whole series of case law that interprets Daubert.
So in federal court, you can make a Daubert motion to try to kick out the expert based on qualifications pretty early on in a case.
And then can they substitute in federal court? I've never put an expert on it in federal court. Can they then, if you succeeded in knocking them out, can the person
I've actually never
replace
seen
that
anyone succeed.
No, usually because in federal court, the judge sets a very strict scheduling order, which lays out every event that's going to happen in the case. And by the time the Daubert ruling is issued, it's too late to add more experts. So, but in my case, for example, which is a class action, we have experts. There's two phases to a class action: certification and then the merit. So in this, we put forward declarations. We call them declarations, not reports, on the class certification. And then after they filed Daubert motions against them, and then later we're gonna do full-blown expert reports, and they'll probably do more Daubert motions again. So this is why we like California State. Or maybe defendants would like to prefer that, I don't know. So what I'm alluding to is in selecting your expert, it's important in my mind to balance the need for an experienced expert witness who knows what they're doing in litigation versus the other side of the balance, someone who's less experienced but more credible and less biased, less baggage. Because I've been involved in expert depositions where it was the person's first deposition, and these powerful defense lawyers come in and just kind of tear them up, even though these guys are totally brilliant engineers and personable and amazing people. It's just a different world getting an expert, having your deposition taken as an expert, and there's so many traps. So you always have to think, like, is it better to go with this person who knows how to deal with the deposition, but there's baggage because he's testified so many times for plaintiffs, and he may have said something contrary in an older case, and they're going to use that against him. And is the defense going to think he's a hired gun? And then the other side is, this expert's an amazing, brilliant person, but they may fold under the pressure of cross-examination. So it's kind of always a balance that has to be considered. Yeah, thank you. Yeah, so here's some of the considerations. Jaime and I collaborated on these. Some of the things to think about are, the CV, the curriculum vitae, which is the fancy word for the expert's resume. Focus in on, are they strong or weak on your key issue? So they may have really, really good credentials, but they don't have background or training in a specific issue in your case, so then you might want to look for someone else. You want to speak with them on the phone, or better yet, in person. And definitely better yet, in person if you can, just to kind of gauge their presence and their authority, and can they communicate clearly, especially if it's going to be a jury trial. Some experts and some lawyers are too technical. They speak using very technical terminology, and that often doesn't do well with the jury.
And I've also just decided against an expert because in the initial 1 or 2 phone interviews that we had, they spoke too fast. And I'm like, if you get up there and you're speaking rapid like that, nobody's going to catch what you're saying, and I'm hiring you to say this stuff and get it across.
Yeah.
So, I've rejected an expert for something as simple as, you just speak too quickly for me. And even when I ask you to slow down, you slow down for a minute, but then you went right back to your pace. That's not going to work for me.
That's a good point.
I could jump in. One observation from a judge's standpoint. If you're doing a bench trial, I think it's very important for you to consider hiring an expert that is not partisan. In other words, the expert has done an equal amount of work for both sides. You could probably get away with something different with the jury, because the other side are probably also going to do the same thing. But in front of a judge, the more persuasive person is the person with the most experience and the most bipartisan resume.
Yeah, that's a good point. And I think, if that expert had been deposed and made some minor slip-ups, I think maybe a judge would be better able to see through that than a jury who could be swayed by, like, oh, he changed his opinion or something. Judges, having been lawyers, know that there could be tricky cross-examination, and they'd be more understanding of the expert and their opinion. So we talked about the audience and professional experts. That's what we talked about with experts who are just constantly testifying, and how much baggage that results in. You know, the deposition transcripts can be out there, trial testimonies out there. In all my cases, I don't know if you have this on the defense side, but in all my cases, I do searches of various listservs that I belong to, and for the expert's name, and I find every comment any lawyer has made about that expert, and then I sometimes call the lawyers, or also look online, and I think Jaime will talk a little bit more about this, just to see what, in this electronic era, there's so much on the internet. We'll talk about some stories of finding some bad things on the internet. And then availability issues, if the person is just too busy, they're stretched too thin, and that happens a lot in the automotive product liability realm. That's an issue because they're not able to really focus in on your case. And go ahead, yeah.
That's become a big thing for me recently, and I've started actually vetting, see other people who've hired the expert, and that's become one of the questions I've asked. And right now I have this expert, or I had this expert, who's just brilliant, best CV you could imagine for the issue. When you speak to him, he speaks in plain language, so he'd be great. He's got this great look to him with the gray beard and the glasses, and oh man, get him up in front of a jury. But I reached out to him and didn't hear back for like 3 weeks. I tried to ping his assistant. I mean, and this is like when we don't have a trial crunch. The one thing I kind of look to when I'm like first getting involved with an expert is, do they give me their cell phone? Something as simple as that. It goes a long way, and when I do my research about these experts, if I know someone else who's hired them, it's one of the questions I ask, because if you have a great expert who doesn't get back to you, it hurts the case.
Yeah.
Where do you find your experts? Is there like a database of experts, or what's the best way to find an expert in the practice area that you?
Yeah, that's a good question. I think it really depends on the practice area, and whether you're doing plaintiff or defense work. For plaintiff's work, there's many different networks and listservs where information is shared. On the defense side, I'm not quite sure because they're so secretive. There's something called the Defense Research Institute, but I don't know if they share information or not. But you can get online and you can look up other similar cases to yours. The best bet would be to look in the federal courts where the experts have actually issued written expert reports. And you can find experts that way and read their reports and make sure that they were successful in the case. Or you can look at jury verdict searches through different companies, and they list the experts who were involved in a successful or unsuccessful trial, and you can rely on that as being a good lead.
It's been a while since I was in private practice, but back then there was a company that had experts of all kinds on all sides, and they were so big and so popular they actually went public, and their shares, I think, are traded. So some of the experts there are owners in that company. I forget the name. I'm sure they're still around.
Yeah, and there's plenty other companies that can find you experts too. Expert Institute is one of them. And I get emails all the time because they know I'm in this business, and they say, hey, we can find you the best medical experts. And I just usually delete them. But there's definitely companies out there.
That's the key, not to delete them, but just put them in a folder.
Oh, that's smart.
And it's really interesting. In my practice, probate bars are very localized, right? So my network is definitely where I go. I probably know a couple of experts already that they're local versus national, right? The local experts, who does everybody go to? Do you want someone that everybody goes to? if you don't want that person that everybody goes to, I literally start calling my colleagues. Who did you use in this case? I know you have this case. So I'm networking a lot. I have never used one of those big services that bank experts, but I've also never needed like a medical expert or a product liability expert or someone that recreates accidents, right? Those people probably get better as they do them, right? Whereas I'm doing valuations. They need to be local, they need to know their markets, right? Standard of care experts. It's really great if you get someone who is a really well-known attorney in, say, Contra Costa, right? Like, for example, I know John Hartog does expert work. If you bring him into Contra Costa as an expert in the standard of care, the judge is going to be like, I know this guy's been here forever, he probably is an expert in the standard of care, right? So, but then there's other things too, like you can look into particular reputations of those local people as well, and you've got to pick someone that's good for you. But I almost always search for my own expert. And then, for example, I just had a large case where we had an interesting compensation issue and we were going to have comp experts. And it was a niche industry. So we literally started looking at who were the biggest players. It was when cable networks were being deregulated, and someone that made a lot of compensation in the cable industry when it was becoming deregulated. And so we looked at who were the top players, who were speaking before Congress then. Are they still alive? Are they still around? Have they moved into consulting work? Because lots of CEOs and people like that move into individual consulting. And they do business consulting, but there's no reason they couldn't do expert work and come in and say, I'm an expert and I go into private companies and tell them how this works. There's no reason they couldn't come into court. And so I'll talk about prep. I just had an expert. It was his first time being an expert. He had a great CV and it was exactly what we needed. And he had court experience. And so, but how do you prep that expert that isn't really an expert? That's not what they do for a living. So we'll get to that.
Yeah.
So if I could just, my 4 steps for finding an expert. This is a big deal. So I've sort of come up with my plan of attack when I need an expert. Reach out to the lawyers I respect and ask them. That's first and foremost. Because obviously you get a recommendation from them, that's gold. And then I go to listservs and just search the type of field I want to find. And then I use verdictsearch.com and I do searches. You can search by expert field, and then you can narrow it. You can start like in the actual jurisdiction, then you can expand it to all of California, and then you can go down, you can go whatever. And then I have actually used a lot of those companies that will pay them a fee, you know, $1,000, $2,500 when the first 3 steps don't work. And then you get information like CV and all that. So those are my 4 steps.
Yeah, that's really good advice. Yeah, I think those expert finding services can be really helpful, especially for a medical expert with kind of a very specific field, and probably in other industries as well. So let's go to the next. Oh, we're already there. I'm going to finish up with once you've hired this expert, you put together your dream team, as I like to call it. How can you take advantage of their knowledge and expertise in the early part of discovery before you get to expert depositions and trial? So I like to use the experts as kind of my teachers and helping me focus what I want to ask for in discovery. So like Jaime said, I review the jury instructions. Usually, for product liability, I pretty much know them, so I know what I'm looking for. But often it's a real, often the issue involves a real technical issue or a specific part of the car or something like that, and I need to know what exactly should I ask the defendants for. So I would kind of get my elements of the case in mind, and then I would call the expert, and we'll talk about why it may be better to call than email in a little bit. Get on the phone and then just start asking questions and coming up with ideas. I just say, what are the, what kind of documents do you want me to get in this case? And I always think that request for production of documents are way more important than interrogatories. Because interrogatories are kind of just the lawyers answering questions with objections and BS. And the documents speak for themselves, right? Those are what you're going to show the jury's going to rely on them, and you're going to show those at trial. So I would first do my request for production of documents using the ideas from the expert, and then some interrogatories, and then clean them up and make them look nice and send it out, and then be prepared for the other side to really object, and then you have to use your knowledge that you learned from the expert to compel what you need. So that's it for me for my talk, but I'll chime in as needed as we go forward. Thank you.
So when your prep starts on your first call and your selection. So don't think that you're just selecting an expert, and then you retain them, and then you start prep. You're gonna start prep as soon as you start looking at them, right? You need to check social, if you've selected someone, you think they're great, you got a good recommendation, Google them. Look at their social media accounts, right? We've all had a terrible experience with someone. I know, I got a mediator one time, I'd never heard of him, who's kind of like my age, a little younger, and I was like, who is this guy, right? Put his name into Google, all these shirtless, like, beach photos were just everywhere. Like, nothing terrible, but like, you're a mediator, dude. And so it's kind of like, and we had a private conversation, like a friend who wanted to talk to both sides, and it was like, you might want to Google your name and like pick stuff up a little bit. And he was like, oh my God, thank you, after he did it. So,
I have one to chime in there that's even worse.
Yeah.
We had an expert that seemed great. He was, highly, in a highly technical area, and I decided to Google him, and what pops up but a mugshot from a DUI online.
So, right, checking that, just Googling your expert and doing that check is very important. And then do it again later. So don't forget to do it again before deposition, before trial, okay? We've already talked about searching court files, reviewing depositions. You might even get video so that you can see their demeanor in the deposition. Do they get angry? Do they get defensive? Maybe you can find these things out if you quickly review a video. I've even asked them, like, give me your bad stuff. Let me see you on a bad day. Do you have anything, right? So we've talked about speaking with colleagues who actually use the expert. A lot of really good input about your expert in that regard. And then reviewing writings by your expert, because it's not just their demeanor and their presence. You're going to have an expert report. So what do their expert reports look like? Are they good, right? Another thing about just expert demeanor, and I know we've talked about it a little bit already, I paid attention to the Michael Jackson estate case. So when Michael Jackson died, his will and trust, his estate plan, didn't include his name, image, and likeness. And so that ended up going through it went through probate and it went through tax court. And there was a huge fight between the IRS and his estate about the value of his name, image, likeness, and also a bunch of his copyrights. And the resulting tax court decision had a lot of commentary on the experts. It was a battle of the experts. There were 4 big experts that were just talking about how do you value these things. And kind of mid-trial, the IRS's valuator, their expert, went out and was like, I'm doing the IRS's $1 billion case. It was like, it got into social media news, like, I don't know, it was big headlines, but it got out into the news and into the world. And it made it all the way into the decision. That like, this guy, like, where's his credibility? He's out there saying that he is the guy for the IRS on the $1 billion case. But his work, and then the court went on to be like, but his work is shoddy in all these ways. So, and he did, and the judge really got into all of the experts in that particular case, and it was kind of a cutting edge case. But, you don't want someone who's going to be arrogant and who's going to speak publicly about your case. So, evaluating all these things about your expert up front is really important. And, if you check social media, I don't know if that guy is really going to ever work for the IRS ever again. So, All right, let's talk about expert communication. We touched on you should call them, not email them. And so let's talk about why. And you should always call your expert and not email them, okay? I don't care what your practice is. That's how you should start. Always make it a phone call, never an email inquiry about anything to your experts. And that's why, if they don't give you their cell phone number, if they're not familiar with the fact that they need to correspond with you by telephone, then they're not an experienced expert, and two, you're probably gonna have some discovery problems. So, expert communication, you got a little typo on the slide. It's protected in most states, not stated, and federal court, but not in California. Right? So in California, your expert communications are discoverable. But so let's talk about everywhere. What are the exceptions? Expert compensation is always discoverable. You always have to put that out there, how much you're paying your expert. Lots of times, I think in California, it has to be right in their reports. I get this much an hour. You're gonna disclose your expert and their rate is right there. And they usually, just for kind of completeness sake, they usually have a rate for all your prep work, and then they have a trial rate that can be higher. Both are disclosed typically. And then federal rules. Facts and data that the expert considered, that's discoverable. Even if they considered the facts or data and rejected it and didn't use it, that's for facts and data. And then assumptions, right? Your expert makes assumptions, and he only has to disclose the assumptions that he actually relied on. So if he considered an assumption and then didn't put it into his report, that's not discoverable. So there's just a little bit of a nuance there that you should be aware of. And again, those are in federal court, but we're in California, so not protected here. Your expert's draft reports are discoverable. Your communications with your expert are discoverable, and that's why you don't put anything in writing. Your first email out to your expert, like, hey, are you an expert in this field? And he writes back, yeah, I do a million cases about whatever the tone is, whatever he writes back to you, that's discoverable. So third-party communications are discoverable. So this is an important point because you need to monitor your expert, right? If, for example, there are two experts, say you have an appraiser and you have an evaluator, and for some reason they need to communicate, you need to be the intermediary and not let them talk to each other directly, right? Because you don't know what they're saying. And so you always need to be very responsive, make sure that you're on those calls, make sure that they're not emailing each other, right? But so everything, and with Zoom nowadays, it's so easy to get your expert. You're having face-to-face, you know you have to travel. There's no reason to be emailing with your expert. One of the other considerations that we haven't talked about yet that comes into, that's relevant to this topic, is that I have hired internal experts that we call consultants, and we preserve the attorney-client privilege with them. They're not going to ever be disclosed, and they're going to stay within the attorney-client privilege. So if there's something that I need to learn, if there's new technology, recently in a case we had a family law issue, and we actually hired an internal consultant family law expert to teach me family law. That stayed inside. They're never going to write an expert report. They're never going to talk to the client. They're never going to talk to the other experts. They're just there to teach me and educate me and make sure what I'm doing is correct. And then I might have exactly the same expert, and then I've treated them differently and communicated with them differently to have them be my trial expert. So I mean, you have to have a case that can finance that, but it's an option, and it's something that I've definitely done before. So, and when you use an expert for discovery, right? Experts are so useful for discovery. You need to know what your expert needs, that facts and data, and you need to get it from the other side a lot of times. So you need to get all the valuation information, all the business documents, all of the accounting CPA files, whatever it is, you need to get them to give them to your valuation expert, right? So if they need something specific, especially if you have a unique issue, you need to talk to them a lot about what you need and how to draft them, right? So I had, like, my family law experts, they wrote discovery questions for me on the family law topics. I don't need to recreate the wheel. I have an internal consultant expert, and I've preserved the attorney-client privilege so I can write to them. They can draft my documents. I can send my pleadings to them, they can review them and redline them and send them back to me. You cannot do that unless you want the other side to be discovering your pleadings and your drafts and your work product with your trial expert, right? Because that's discoverable.
So, and my understanding is the same expert, and there are just 2 engagement letters?
No, you can't have the same expert. They have to be 2 different people if that's the way you're going.
Okay, because it's sounding like you hire the same exact expert.
So same subject matter sometimes,
Okay.
right? Like I might have 2 family law experts. One is gonna be my trial expert, and I'm gonna be very, very careful with communications with them. And one is going to be my internal consultant, and they're gonna be within the attorney-client privilege, and I can write to them and exchange drafts with them, and they
And
will
it's
never.
2 firms.
Yes.
We're talking about, not
Yes.
just 2 lawyers.
Right.
But shouldn't you always, when you get an expert, 95% of cases settle. So I always retain experts. For example, I do a lot of landlord tenant law, and if I'm getting a mold report, I always retain the expert rather than the client because I don't have to disclose to the expert till close to trial, and I'm expecting every case to settle. And so I don't want to have to, for example, produce a bad mold report to the other side if I get a bad mold report. But I do need to get a mold report in order to evaluate the case.
Yeah, and if you have a case, and I don't know if you're a trial attorney or not, but as a trial attorney, sometimes I get these cases that are all worked up, and then they get trial setting hearings set, and they go, hey, Jamie, come take my case. And I would say to you, I have to dump your expert. Because you have talked so much to your expert, and you have bad expert baggage, that I can't take your expert to trial, and I need a new expert, and I'm probably in a crunch to get a trial expert.
It's a great division. I always call them a consultant
Yeah.
until they became an expert. I love the word internal. I tell clients, think of it as a paralegal. We can talk and nothing comes out until you get to the disclosure part, and you're probably not disclosing that person. So it is a separate expert in a separate firm in maybe the same area.
That's right.
So
Yeah.
Jaime, I have a question. You were talking about drafts for the testifying expert. You might be protected and must be discovered. What is your view about notes that the expert takes, the testifying expert takes during meetings with you or with anything else that they're looking at, file notes and meeting notes?
So in California, I think most of their work product is discoverable, right? So it's one other thing I do for prep, especially when you have, especially I do it for everybody. It's different when you have a professional expert and when you have someone new, right? I need to coach my new guy through this and tell them how much do you write down, what do you keep, what's your normal practices, and coach them through it. Whereas someone who is a professional expert should have these policies set. So instead of coaching them through what is your retention policy, they should be telling me, what is your normal retention policy? Do you testify about this? Is it in your depositions? Are you consistent about it? Has it changed over the years, right? They should know what they're retaining and how they're retaining it, and they should have some procedure for producing their file. Like, look, when I get the discovery request that says produce your expert's notes, what do you typically produce? And your professional expert should say, this is what I do, this is my practice, this is what you're gonna get, right? I prefer an expert who doesn't handwrite notes. Like, I don't wanna deal with that, it makes it so much more difficult. But when you get a professional expert that has assistants, there's an interesting dynamic there. So, do they prepare like cheat sheets? I put on here cheat sheets that the testifying expert relies on. So do they have junior staff that's doing the grunt work for them, and they're not in the weeds on it, and they get some kind of mini report or cheat sheet from their people? That cheat sheet is probably discoverable, and I don't like that. I want an expert that has enough time and commitment for my case that I don't care if you have someone do all the work for you, you're gonna get in there and know all of that work and not need this mini report, this cheat sheet that's internal. So I asked specifically about that, and about kind of the division of labor, and if they have those worker bees, how do they go back and learn the subject matter? And when do they go back and learn the subject matter? In my most recent trial, my expert got grilled about it because she's a forensic accountant, and she was up there, and she's like, look, I don't spend a lot of time putting in, like, there was a giant general ledger, handwritten general ledger. She's like, I don't input data. My staff spent hundreds of hours inputting data, creating Excel spreadsheets. I don't do that. So when I get up here on the stand and you're like, only 20% of the hours were yours, she was like, she knew she was a professional expert. She was like, yeah, I don't do that kind of work. That's not what I'm paid for. I look at the spreadsheets on the back end, I manipulate the spreadsheets, I give the directives on the spreadsheets, I own the spreadsheets. I'm not doing any data input though. And that's the bulk of the hours. So she had a really great response. And so you kind of need to be familiar with that, right? We have a little bit of a back and forth here about if you're not covering these topics with your expert, they can kind of get drilled in their deposition. So we created a little back and forth about what's fair game in California. And I'm going to be an attorney here, and Todd is going to be the expert. And we're just going to do a little mock, just short deposition, all right, of an expert. So again, I'm the attorney, he's the expert. Here we go. How many drafts of your report did you prepare?
I don't recall the exact number, but there were several drafts.
And what did you do with these paragraphs?
They are written over to create an updated document.
And you said that's your normal practice. Is that what you did here?
Yes.
Did you send those drafts to counsel for the LLC valuation?
I emailed them.
So when you said you normally write over drafts, the truth is that the draft still exists, and it was an attachment to your email.
Yes.
And I'm assuming you still have those emails?
Yes.
And how many were sent to counsel?
Again, I don't recall the exact number.
Did you send the drafts to anyone else?
I don't recall, I might have.
Did you send them to any non-lawyers?
Maybe the CPA on the matter?
Did you produce those with your disclosures?
I did not, only the final document.
Did anyone in your firm have any written communications, including emails, with anyone outside of retaining counsel's office?
We had a couple analysts assist on the matter. I don't know if there was any written communication.
And did you produce those with your disclosures?
I did not, as I was not even aware if there were any.
How did you learn the facts on which you relied in performing your analysis?
Financials were provided by the CPA and additional information was provided by counsel.
And how did you communicate that? Telephone, email, fax?
I believe mostly email.
And how did you learn what assumptions you were to make in performing your analysis and evaluation?
Our assumptions were communicated to us by counsel.
And by telephone, email, or fax?
I believe telephone and email.
Did you review underlying documents supporting your report?
I did.
And did you identify those documents in your report? So at this point, your expert is feeling uncomfortable. You didn't prep them that they were going to get asked these things. And really, these are things that I think you should be asking very early on in retaining this expert, right? If you already know what their practices and procedures are, your expert's not going to feel this way, right? And asking about, hey, expert, how many drafts did you prepare? You're probably in the first couple minutes of your expert's depo, and now your expert, they're off their game, right? So if nothing else, going through these types of questions, making sure that they've disclosed the right things. I mean, that's really on you. You're the attorney. The disclosure should be right, and you should be doing these things with your expert and making sure they have good answers to all of these types of questions, right? So, and it all starts kind of at that very initial, like, how are you going to treat your expert?
I'm surprised to hear you talking about expert reports. I never have my experts prepare reports. I specialize in legal malpractice, and I'll be damned if I'm going to have my expert explain that before his deposition, ever.
That's a good point. And
Ever.
I think, so yeah, it's really depends on the practice area, and I think since Adam and I both do plaintiff's litigation, and when we're in state court, we're probably not going to do expert reports either. I totally know what you mean. In federal court,
It's all discoverable if you have an expert report. Why would you be dumb enough to give the other guy a shot at it?
yeah, definitely.
Unless, there is an exception, unless you have such a rock-solid case, and you want to intimidate the other guys, as you discussed, then you do something like that. But otherwise, no.
Well, here's another strategy that you can look at. If you're going to mediation and you have a rock solid case like that, and you want to really pressure the other side to settle, you can have your expert do a report for mediation purposes only, and write on the top, mediation, or privilege for mediation only. And then they can't use that against you in discovery or trial later, it's just for the mediation.
That's interesting.
Yeah.
I never thought of that. That's a good idea, very good idea.
And this is definitely a point of strategy, case by case. And it's kind of, I worked at a small firm in a litigation boutique for a lot of years in my practice, and now I'm at a big firm. And at the big firm, I'm not the last call in the case, and we would never not do an expert report. That is the big firm protocol. It's risky not to do one. You're hiring this expert for the report. Why would you not get the report? They consider the other path to be too risky. So,
They think it's too risky not to have a report.
not to have a report, like not to follow standard procedure, right? Like experts are for reports and you depose them, right? I mean, you just do things in sequence in a big firm, and to deviate from that sequence to a more high risk or a low budget strategy is not the MO at a big firm, right? So it's an interesting thing going from a small boutique where you're really customizing your strategy to your case and your client to going to a big firm where they kind of have policies and procedures that you follow. But the cases at the big firm are also so big that the other side is doing it that way as well. So I have actually never not used a report, just been the course of my cases. But I've oftentimes tried to decide whether or not to depose the expert. Right? Because when you depose, say the other side has an expert, they produce you a report. Well, do you want to depose that expert and point out everything that expert did wrong so they can correct it so that at trial they have a better report? Right? And so that's often in my practice where you get into the back and forth. Do we depose them? Do we not depose them? And if you have multiple experts, do you depose them all? Do you depose one of them? How much do you need to know about the other side's strategy too? How much do you need to know about this expert? If you can't find a lot about the expert in your network or by Googling and researching them, maybe you just need to see the other side's expert's demeanor at a deposition. So all of these things, I think it's case by case, but this is definitely something you should consider. Is your expert going to have a report? I mean, maybe it's not even in your budget to have a report, you just need them to come in and testify. That's totally a legit consideration because expert reports are expensive, right? Expert depositions are expensive. If you have a report, you probably don't have a deposition, unless, you get into these other strategy things. And if they're not, if you've gotten an expert, put an expert report out there and the other side is not deposing your expert, you better really look at your expert report. Is there something in there that they're not pointing out to you that they don't want your expert to fix before trial? I'd definitely give that a look. Like all these things are strategy things that come up in the course of your litigation. So, all right, so we did skip ahead one. Oh.
Before we move away from this dichotomy of retained expert for trial or internal consultant, assistant internal consultant, is that privileged or not?
Privileged.
The communications are privileged, but whether they exist, is that, yeah?
It is. It's completely privileged. You do not have to disclose your internal experts.
Good question.
Yeah.
Oh, and I'm counseled by opposing counsel to all that stuff, so just make sure.
And also don't be intimidated by the thought that you need to have a consulting expert and a testifying expert, especially on the plaintiff side or a smaller firm. We're more like cowboys, and we kind of do it without all the bells and whistles sometimes. So.
Yeah, definitely. If you're not in a really high caliber kind of case, you might not ever have an internal consulting expert, or you might bring them in for like a one-off thing. Like you have a serious tax question, And, you know, it's just one line in whatever evaluation report or something, and you just need to understand this tax issue. Maybe they just come in for 5 hours, right? And they're your internal consultant to help you understand the tax issue, to make sure you wrote that tax issue correctly in your pleading. And then maybe if I've also used internal consultants sitting in the courtroom. So if the other side has a tax expert up on the stand, my tax consultant is sitting in the courtroom texting me, like, they said this wrong, this is wrong, cross them on this, right? Because I'm not a tax person. So I've used internal consultants in that way. And nobody knows that I have someone feeding me cross-exam questions. It just looks like I'm a tax expert too. All right, so.
Now you know.
Yeah, right,
Yeah.
my secrets. Okay, so you've hired someone, you like them, they've done a report, or they haven't done a report. You need to prep them. It doesn't matter if you're prepping for trial testimony or depo. Practice. I like to do a 2-hour depo practice where ideally I get someone in my firm who's unfamiliar with the case. I give them the expert report, and someone who's unfamiliar with the case, I even give it to someone outside my practice area. And when you do that, they find every typo, every awkward sentence, every weird thing on the CV. We point out social relationships, and for 2 hours, we just drill the expert on somewhat meaningless but really awkward topics, right? I want that practice session with my expert to be the most uncomfortable thing they do in the entire case, right? And so I just get, and I usually am not, in the practice session, I'm usually not the deposing attorney. I usually just listen in. Like I said, I kind of have a stranger outside the practice area. I'm like, just come in and be a asshole to my expert. That's what I do, and right? And so I just, in my most recent trial, I had this great guy. He's a standard of care expert. He spent years running trust companies across the nation and managing trusts. And he's just going to come in and he's going to educate my non-trust judge, because we got kicked out to master calendar and assigned to someone random, non-probate judge. Just going to educate her about the standard of care and trust administration, right? He had great experience. This is what he's done for his entire career. He recently retired 2 years ago and started his own consulting firm, and this was his first testifying matter. He had a number of things lined up. And actually, we weren't his first testifying matter because another trial got to trial right before us, so we were actually his second. But when I was prepping him, we thought it was going to be his first. And so this is what we did. And like I said, every typo in that report, and then he knew where all the typos were. So as he was up testifying, and he would just point them out right up front, right on direct. And that's a typo that should have been. So there was no cross-examining him on typos live at trial, because he had already pointed them out. He knew where they were. He'd already been through that with somebody. So that's all good, right? And then again, going through that past testimony, publications, anything on the time card issue, like are they working more or less than assistants? All of those are really good questions, just to vet them out. What is he gonna say? And then I really like to use hypotheticals. Like, just throw random, improper hypotheticals at your expert, and what is he gonna do? Inevitably in a deposition, you're gonna get a random hypothetical. And he should have some great canned lines. I can answer that hypothetical in several ways, right? Or I can't answer based on the facts you've given me, right? So he should have canned answers to their hypotheticals, and then he's pressed. So I really like to go for hypotheticals as well. Yep.
So at this point, we're gonna hear from Judge Baskin on some trial matters. I didn't realize that I forgot to point out Judge Baskin. He is retired from the bench, but he's currently doing mediation in jam. So I forgot to mention that that's his current role. More time to make Chris sit at home, I think.
Sorry about switching seats, but I've got to get into toggle switches here. So difficult from that end. Adam, thanks for that introduction, but you did have a material omission And the material omission was that when I was talking to Tam years back about Iron Man, I discovered that he was not only entered, but in doing the Hawaiian Iron Man. And so I told him, now that I'd heard that, since he was half my age, I told him he had to finish in half my time. And he laughed just like all of you did. He went on, and he did, in half my time. So he's quite an athlete.
The faster you go, the sooner it's over, that's my opinion.
All right, so we're going to get into this topic here, which is CCP 2034. You all know what that is, but ask me to pick a topic that comes up at trial, and it is surprising, and still is surprising to me how often it is that practitioners are not really aware of the pitfalls of 2034. So let's just look very quickly. The requirements under 2034 require you to provide an opinion and its basis. So that's my little summary of it. But if you look at the letter of 2034, you'll see that it doesn't actually say that you have to give the opinions, or the bases of the opinions. It doesn't say that. It's a lot broader. And it requires you to give the general substance of the expert's testimony. And so what I have found happening is that a lot of practitioners fall into the trap of giving a 2034 that just has the general substance. And when you get a 2034 that doesn't have the opinions or the bases for it and just has the general substance, you need to be 100% sure and clear at the deposition to find out what the opinions are and the bases of it. And you might think that I'm telling you something that's so obvious, you're wondering why I'm telling it to you. And I'm going to show you why in a moment, because what happens, this is not an atypical scenario, is that a lawyer will give this general substance notice in a 2034. And let's say the opinion that the expert gives is A and B. But the lawyer also wants to get an opinion C, but it has not yet ventured about opinion C. And the deposition comes, and the expert testifies about opinions A and B. And the expert is asked, are there any other opinions? No, there's no other opinions. And a little closer to trial, the lawyer then gives the expert some additional materials and some additional pieces in order to get to opinion C. And now, suddenly at trial, opinion C is on the table. And you might think that that's an unlikely scenario, but it's not unlikely, and it's been the subject of 2 cases that are reported. So you know that it's been reported and it's come up dozens of times, and it certainly has in my courtroom many times. So let's just talk about what the risks are and what the do's and don'ts are under those circumstances. These are the cases that are conflicting with one another, but if you really study them, they're really not that conflicting, and they really are consistent. In the one case that's cited first there, that's Jones versus Moore, the expert testified that no additional opinions would be offered at trial, but then at trial wanted to opine in a way that the lawyer then argued was covered by the original 2034 notice that had been provided. Remember, it's the broad notice. Well, the court agreed with the lawyer and said, yes, it was covered, but since the expert said there were no additional opinions that he was planning to give at trial, then that opinion, that additional opinion, could not be given. In contrast, the next case is De Palma versus Rodriguez, and there the Court of Appeals held that where the trial expert testimony constituted merely an expanded description of the deposition testimony, then it is properly admitted. So what's the difference here, and what's going on behind the scenes that you can get this seemingly contradictory cases? And what happens, and this is where it's very important, at the deposition, you need to nail down, and there's no limit, I'd say ask it 5 different ways. To ask the expert, are there any other opinions that they plan to or intend on offering? And if any of the answers that you get are the slightest ambiguous, so that there may be, then you need to, on the record, say that you want to know the moment such an opinion is formulated and have the expert available to give a supplemental deposition and perhaps even object to that opinion altogether. But unless you are prepared to go to the judge and say that you asked for that, they said there were no opinions, you can expect those additional opinions may be allowed, especially if it was within the parameter of the original 2034 notice. So in order to cover yourself at trial and not have that situation where the unwanted opinion that's on a critical element that you might have thought you were good to go on suddenly is undermining your defenses, your case, you want to make sure that you cover that perfectly. Ideally, you even want to deal with it in terms of motions. So there's 2 ways you can approach it. There's Evidence Code 802, which allows you to ask leading questions if you need to for the expert, and allows you to lay out the opinion of the expert. But remember, the last part of that section leaves it to the judge. The judge gets to decide whether or not you would be required to lay out the factual basis for that opinion first. So obviously where there's an additional opinion that you didn't know about that suddenly is surfacing at trial, if you haven't done all that homework that I told you about, you want to make sure you have that 802 hearing, preferably with the 402B hearing, which is outside of the presence of the jury, so that you can do the discovery you should have done earlier on. So now you're in damage control mode. That's why I'm saying you've got to really try to do this and nip it in the bud before you get to trial. The deposition that this battle is fought and follow-up correspondence. So if there's any ambiguity, the day after the deposition, send out an email saying, are there any opinions? If so, what's the basis? When is an amended report going to be filed? When is an amended 2034 response going to be filed? When is the expert available for further deposition?
So I've listened to you, and when is the expert going to give additional testimony? 2034.280A requires the defendant or the plaintiff to amend his expert disclosure when he sees that the opposing expert is going to testify to things that are relevant but they didn't think of. In my case, their expert only talked about the standard of care, and my expert's going to talk about fiduciary duty, and I disclosed my expert when I deposed him. I said, are you going to testify about fiduciary duty? I asked him 3 different ways, just like you said, and he said no. And then I got counsel to say no. And now they're telling me that he's going to act as a rebuttal expert for fiduciary duty, and I've got a motion to eliminate to stop it. Right. But I don't know what the judge is going to do. Right. If she doesn't agree with me, I've got 2 choices. I got a writ of mandate, or I guess I can depose the guy again, but I really don't want to depose him. I want to preclude him from ever opening his mouth on fiduciary duty. Any suggestions?
Well, you've got those 2 cases that I just gave you.
Oh, I know the first one, but I didn't know the second.
Yeah, the second one is a little different, but it's still got the same thing about surprise. So the judge is going to be concerned about the element of surprise. If you were clear at the deposition and they were clear about it, then you are being sandbagged.
But the judge could say, well, I've got 3 more months, she had to continue my trial, and she said, we can depose him again. But I don't want to depose him, I want to preclude him.
Well, that's,
Do I have to take a writ? That's the question.
That seems like it's in the court's discretion.
yeah, it's in the discretion of the
Yeah.
court.
Now, one thing-
If the judge allows you, I would say, you know, if the judge allows them to do it, I think you are going to be required to take a deposition. Your chances on a writ are slim.
Another strategy that I employed is when the other side was adding a new expert right before trial, when we were in the courtroom, which was a location pretty far from where the expert lived, I demanded that there be a 402 hearing in the courtroom. So the lawyer had to call the expert and say, the judge needs you to come to court and do this hearing to decide whether your testimony is going to be admissible. And then that expert, who was a commonly hired expert for the other side, was too busy and he couldn't come to court. So then the judge said they can't testify. So try to call them before the
I don't have
trial.
that issue, the guy's local, so.
Well, you can still try it.
I have one last question, Judge Baskin. Sometimes the experts, they're in love with themselves, and they say, well, I'm not, that's the end of my opinion. So what I've done when I hear that kind of silliness is I start deposing them myself. I mean, I literally ask my own experts questions, and I cover the issues I know I need to cover. Do you think I'm covered at trial when those questions have been asked, but after my expert has said, those are the ends of my opinions?
I think as long as you covered the substance of opinions, it's covered.
Okay.
There's no surprise.
All right.
There. All right.
Yeah, and I agree that surprise and prejudice are going to be your best arguments, and their best arguments to get a rebuttal expert in, I've always found, is that someone's going to say, I need my day in court, like you're denying me a response, right? So those are your dynamics there, and I've seen judges kind of come down like a hammer on deadlines, if that's the judge's MO, and then I've seen judges be just very lenient with this kind of thing, like I want all the evidence to come in, and then we're going to decide at the end of the day, but I'm not going to preclude evidence up front. And I'm kind of like, you can kind of tell from your judge.
I already know the answer to my question. I have a very nice person who's going to give the other side the benefit of the doubt.
There you go.
All right. So, one.
As an expert, if I'm deposed first, how do I handle that question if I'm then asked to rebut the other experts' opinions and they haven't been deposed yet?
Well, when you are asked what all your opinions are, then you could say, I might be opining on what the other expert testifies to.
So then I get deposed again.
Right.
Yes.
That's absolutely right. All right, so another thing I wanted to cover about common pitfalls with experts, moving away from the 2034 context, was I often see lawyers, you all know that once the side calling the expert has finished laying out their resume, the judge, and asks for them to proceed as an expert witness, the judge invariably will ask you whether you have any voir dire. And it's stunning to me the number of times that the lawyer has stood up and said yes, and then has gone and questioned the expert on their expertise. So I'm not sure what advocacy school that's from, but I was told, never ask a question of a witness that's not going to advance your case. So once you're asking about the expertise of the other witness that's against you, you're just adding to their the way they're hurting your case. Don't do it unless there's some real reason there that's going to knock the expert right out. I would say there is no voir dire and this expert can proceed. Don't do that. The next thing...
If I could just jump in.
Sure.
I saw another lawyer, they thought that the fact that an expert didn't have like this particular experience was like their gold nugget. Let me get out in front of the jury before they give their testimony and all that. I'd like to do the voir dire. Well, isn't it true, you know, so-and-so, that you never did this? These expert witnesses are smart. He's like, yeah, but I did this, you know, just totally. And then it was like, well, what just happened there? That was great for that expert. So you may think you want to get up there and in front of the jury point out all the things that this expert doesn't have and my expert has. They're going to give you a yeah, but. They're not going to say, oh, yes, you're right, you know. They're going to give you a yeah, but. It's going to hurt. And there's other ways you can point out that good fact about their credentials.
And what, like making a comment to the jury in closing, or?
Yeah, I think
That's
it's,
the place.
that's the place. When the expert's
I'm
out,
hiring you. I'm hired, thank you.
when the expert's
I
gone.
hired him. Big Casper did that, man.
All right, so I'll go to the next topic, which I see a lot of, which is that you are allowed latitude in asking an expert witness leading questions when you call in the expert as your own witness. So you're allowed to do it, but that's not the question. The question is, do you want to do that? You've paid your expert, you know, thousands of dollars. You're probably paying them hundreds of dollars an hour or maybe thousands for the day. And they have, the reason you hired them is their ability to speak. And so to ask leading questions is limiting their ability to speak. I would not do that unless you're on the background in their resume. I would not ever ask a leading question of my own expert. Let them talk. Let them. Don't lead them. Do it with open-ended questions. You've done the prep. You don't need to ask leading questions. So that's a fairly common thing. And just as common on the other side is when you cross-examine the other side's expert, always use leading questions. Never ask an open-ended question unless you want the expert to hit another home run.
Exactly.
Yeah, it's just not the thing to do. And yet, I can't tell you how many times I've seen that happen over and over again. It's just not helpful to the case.
And play with the form of your leading questions, because an expert might give you a yes, but, or no, but, if you ask it one way. But if you say, you said this, didn't you? Maybe you catch them and they stop the but, right? Change your format of your leading question, and there's going to be one that it's harder for them to say the but, and they're going to start giving you yes, no's. And when you start getting your yes, no's, stick to that form of your leading question and bang through your points.
All right, so then the next area that we've got to touch on is Sanchez. And I'm hoping, can you all raise your hand when I say the Sanchez case? Are all of you familiar with the Sanchez case? Raise your hand. Raise your hand if you're not. Okay, so let's just talk very briefly.
Am I fired?
Pardon me?
Am I fired?
You'll remain a consultant.
I will refund you your fee here. Before Sanchez, an expert could testify and could rely on, and you could have admitted into evidence, hearsay evidence. That's the important thing. So, for example, a gang expert in a criminal case would come to court and say that he based his opinion that the defendant was a gang member on discussions with several other gang members who admitted that they were gang members and who admitted that that particular defendant was a member of the gang. And remember that those other gang members are not going to be testifying in court, not if they want to live. And so it's hearsay, it's classic hearsay. And before Sanchez, that type of testimony was routinely used by prosecutors in gang-type cases. Post-Sanchez, that became impossible. You no longer were allowed to use out-of-court statements. And so Sanchez terminated the ability of an expert to rely on inadmissible hearsay as the basis of their opinion. And there's a lot of cases that discuss Sanchez and explain it and vary it, but it is an issue on experts, and it's something that I think with our limited time we can't spend too much time on, but maybe our panelists want to just chime in about their experience with Sanchez and how it's affected you.
Yeah, I bring a lot of lemonades around Sanchez, and oftentimes I get a response from the judge saying, oh, you want me to follow the law, let's just eliminate. But I point out, like, Your Honor, I just want to bring it to your attention now, because I don't want to have to do an objection, move to strike, and have to unring the bell. And I want to point out that particularly this witness, when I took his deposition, he said he's relying on this doctor who said this, but that statement by the doctor, they don't have that, they're not calling that doctor, we can't have it come in, and the judge does give me that, you're asking me to follow the law, but it's been highlighted. And then if counsel dare, if their witness says it, I mean, the judge is going to be very upset because it was addressed in limine and things like that. But what I'm so uncomfortable about cross-examining an expert is opening the door to it. And I just feel like in trial, I'm just like walking on eggshells at times around going after the basis of their opinions and things like that, and they're going to slip it in, and the judge will feel like you opened the door, you went there, you had to say it. You know, like you brought this on, so it's challenging. Sanchez presents a big challenge, and when I trial prep, I go and I basically make a giant Excel sheet of all the necessary facts I need to prove my case, all the bad facts, who's going to testify to them, and it helps me lay out where all the evidence is coming from, and that's when I figure out what my eliminates are going to be in terms of Sanchez issues.
Do you think we have time for a little quiz on Sanchez?
That sounds fun.
All right. So up here is the hypothetical. I'll just read it for those at the back who may not be able to. And that is, a plaintiff sued a defendant for injury sustained in an automobile collision. During the plaintiff's hospital stay, a staff physician examined the plaintiff's x-rays and said to the plaintiff, quote, you have a fracture of two vertebrae, C4 and C5, unquote. An intern who was accompanying the physician on her rounds immediately wrote the diagnosis on the plaintiff's hospital record. At trial, the hospital records custodian testifies that the hospital record was made and kept in the ordinary course of the hospital's business. So the entry reporting the physician's diagnosis is, and here are your choices. So, take a moment to just jump through the choices, and then we'll see where you were. Correct answer here depends on your getting the certificate of completion.
Does that go for speakers too?
Yes.
Oh gosh.
Okay, so who decided A is the answer? Show of hands, quick show of hands. All right. B. Also more hands. C. Okay. D. Okay. All right, so you can't all be right.
That's true. And Judge Simons is not here to tell us the answer.
He's not, but I have taken it from him. So he has the right answer. Okay. So that's an important thing. So it's really affects Sanchez's problem, this quiz was. So that's a very important thing to always look at is it really inadmissible hearsay, or was there some other basis for it to come in?
So if you, in my case, I've subpoenaed the adverse party's records, and he's got all the records that I want. My expert can rely on every single document in his file. Do you not agree? That's the same as Deeper.
It depends what the records are.
Well, if it's
an
an email exchange between the expert or the defendant and my client.
So they're not hearsay. because it's from a party and it sounds like it's not his.
And what about his descriptions of why he did it? And
That's also an admission of the party opponent.
Okay.
Yeah, so it's not his.
You're not in the realm of Sanchez unless it's hearsay with no hearsay exception. And this business record, get in all kinds of stuff you don't want, as far as hearsay, I think. So it's broad exception.
Yeah.
I have a question, Judge Baskin. How hard is it as a judge to try to make these decisions like so quickly when during the flow of the trial where you're constantly having to think, is there a hearsay exception here? Are they right? Are they wrong? Does that just come with experience or is it?
No, it's impossible to do.
Yeah.
But what happens is, and you hit on it at the beginning, which is the eliminates come in. And the judges won't typically rule on the eliminates because they want to hear how the evidence actually comes in. But it alludes you to what the evidence potentially is, and that's why you're not really so surprised when it comes. Then you are ready and you know what the law is, and then you can rule right there and then. So it's always a good idea with Sanchez to have motions in limine. Definitely, always good.
Thank you.
Do we have time for questions?
We
Yeah, we have just a couple minutes left.
Yeah, we have a couple minutes. There are questions. Feel free.
What's the site on Sanchez?
Oh, the site of Sanchez. I've got it. Okay, it's a pen. Who asked for the site?
No,
You got it.
Are we able to get copies of those slides? They weren't in our materials.
Yeah, I mean, reach out.
We had sites that I wanted to grab on this.
Yeah, just, you know, be like $50 or something. We accept Venmo, Stripe, Zelle Pay.
Email me, I'll send them to anyone who wants those.
Yeah, if you reach out to any of us on the panel, whoever, pick who you like the most.
Yeah,
And
exactly.
you can email me. Listen,
I have kind of an off-the-wall question about experts. Any rules or ethical issues regarding the former general counsel, would be of a state agency, testifying as an expert against the state agency?
And what do you think the issue is?
Well, it's about the standard of conduct, the ordinary course in the agency, and it sounds like, I mean, to me, and this is more of a gut reaction, and I'm retired, so I'm not actually doing this, but I had this happen when I was still working in the house. He wouldn't let me make the objection for their own reasons. But it really bothered me that a lawyer who has lots of fiduciary and ethical duties while on duty can retire and then come back and testify against his own client about what was going on in that office when he was on duty.
Again, it's a Kenny Fry issue. I don't know if the lawyer had the necessary expertise to talk about what that agency was doing factually. I don't know if it was legal.
Well, it's more of the ethical, whether lawyers are, you know, like special kind of experts, and you got to look at other issues about whether they should.
Wouldn't that go to weight of the experts stand under cross-examination and look at these conflicts and things?
Sounds more like recipient than standard of care.
Yeah, that's what I was.
Standard of procedure.
That's why I asked that.
You always think about weight versus admissibility, right?
oh, that's one of my favorite retorts to any objection. Just have that ready on the tip of your tongue. For any objection, keep something up. You can't think of the actual response.
That was the way, not the
Yeah,
Okay,
yeah,
thank you.
that's a good one.
Just, anyone else have questions? I'm curious.
I have one question. Judge Baskin, this is for you. So I have filed multiple motions in limine and I've got a hearing very shortly. But the trial date is next year, so the judge is going to have time to let me take depositions that I really don't want to take. The question is, if she rules adversely, should I just wait the trial and you know, I've alerted her to some they're all complex legal questions because it's a malpractice case. So I wait for the trial and just hope that she's going to get it because these are not easy.
And I would do whatever you need to do now. Do your due diligence, take depositions, even though you don't want to do it. Take a shot at getting the judge to exclude it now, ahead of time. But like you said, it's probably a long shot and unlikely. So if that motion is denied, then take the depositions.
All right, thank you.
Yeah, I think that's the end.
Anything else? Thank you, everyone.